Imagine hearing a knock at your door and finding your landlord outside expecting to come in. Can a UK landlord legally enter your rented property without your permission? It's a question many tenants aren't completely sure about. Knowing where the rules stand is essential for a stress-free tenancy. Today, we're looking at the legal reality of property access. In many UK rental situations, tenants generally have important privacy rights. This is a fundamental part of your tenancy. It's often referred to as your right to quiet enjoyment, the right to live in your home without unnecessary interruption. But of course, there are balanced situations where landlords may be allowed access, provided they follow the correct procedure. The law aims to protect your privacy while allowing landlords to meet their maintenance and safety obligations. In many circumstances, landlords are generally expected to provide notice before entering a rented property. Usually, this means giving at least 24 hours written notice. This is a standard requirement for most inspections. The visit should also be at a reasonable time of day, usually within standard business hours, unless agreed otherwise. Notice is required for routine maintenance, gas safety checks, and pre-arranged property inspections. Crucially, you have the right to decline a specific time if it's inconvenient and suggest a better alternative. However, emergency situations may be treated differently. In these cases, the standard notice rules may not apply. This includes serious flooding, fire risks, or major leaks that require immediate action to prevent property damage. If there's an immediate safety concern, a landlord may have the right to enter quickly to resolve the issue. Urgent gas safety issues or structural concerns that threaten the building's integrity also fall under this category. While rare, these exceptions exist to ensure the safety of both the property and its occupants. Your tenancy agreement is the key document that outlines the specific access arrangements for your home. It should detail how much notice is required and the circumstances under which the landlord can request entry. Some agreements also include details about property viewings if you've given notice to move out. If your agreement is silent on access, the general legal principle of quiet enjoyment still serves as the baseline. Always make sure you read these sections carefully before signing any new rental contract. Clear communication and written notice can help reduce misunderstandings between you and your landlord. It's always best to have a paper trail. Confirm any access arrangements via email or text message. Most disputes can be avoided by simply being clear about schedules and expectations from the beginning. Keeping a record of all communication ensures that both parties are on the same page and follow the rules. This documentation is your best defense if a dispute regarding property access ever arises. If you're currently renting, there are a few simple steps you can take to stay protected and informed. Keep a dedicated folder for your tenancy agreement and all written communication with your landlord. If you feel your privacy is being breached, don't hesitate to seek advice from organizations like Citizens Advice. Remember, your home is your private space, and the law provides a framework to help keep it that way. Being proactive and informed is the best way to ensure your rights are respected throughout your tenancy. This video is for educational purposes only and does not constitute legal advice. Housing rules can vary. UK housing rules depend on location and tenancy type. Subscribe for more simple legal and housing explainers. Thanks for watching, and we'll see you in the next guide to understanding your rights.